One thing is certain, that these laws, when challenged, cannot pass the test of constitutional validity, because it is a clear violation of the fundamental right under Article 21.
सरकार भी निर्णय ले रही है कि हम लव जिहाद को सख्ती से रोकने का कार्य करें।
Or what it tries to address is that it tries to prevent conversion, religious conversion, which is on the basis of any force or fraud, allurement, misrepresentation, or by marriage. Any conversion which, according to this law, has been done unlawfully, which is if there is any marriage, any conversion done by marriage or by force, allurement, coercion, or misrepresentation, any of these factors are involved, then such a conversion would be illegal. It would be a criminal offense, and the marriage on the basis of such conversion would also be declared void. Allurement is quite a new term. It's not really a legal term. Allurement has been added to say that if anybody converts a person by tempting or alluring them with any gift or money or exchange of any other goods or even a better life, that is, or employment. If a person or a couple seeks to marry and someone wants to convert for marriage, then there is a certain detailed procedure which is laid down. So a person who wants to convert his or her religion has to first make an application to the district magistrate in advance, I think at least 30 days in advance. The district magistrate will then take that application and conduct a detailed inquiry with the police of the whereabouts of the person, of the family, residence, and all other details. Simultaneously, even the religious converter, so the religious heads who will be carrying out the conversion, also have to give an application and declaration of this to the district magistrate in advance, saying that such and such person has applied for conversion. And only after the inquiry of the district magistrate, which would be after conducting, in fact, a police inquiry, and approval is given, then the person can convert. After such conversion, the law also says that there will be a declaration put up, a time-based declaration, which will be put up by the district magistrate in the office, in the district magistrate's office publicly. And this will be put up to ensure whether there are any objections or any oppositions to this. So these are, these are the requirements. These are quite onerous because this means that at any stage, either prior to or after the conversion, any family member of the person converting can effectively raise an objection and stall the conversion. The Supreme Court has very recently, in a series of decisions, held that the right to choose one's partner, the right to decide who to have intimate relations with, whether to live in or to marry, are all an integral part of our fundamental right to life under Article 21 of the Constitution. The right to life includes the right to autonomy, liberty, and the right to make decisions most personal to us. And that includes the right to choose one's partner. In a few cases, especially in the Hadia case, where a woman, an adult woman, had converted to marry the person she wanted to, the court held that matters of faith cannot be seen as infringing a person's right to choose one's partner. And even if a person decides to convert from their faith, even if there is no family approval or social approval for such choices and conversion, when there is a decision made to choose a partner or to marry a partner, that is an integral part of that person's right to choose and that person's right to life. And the state cannot intervene in this choice or take away that choice in any way. It was held in the important right to privacy judgment of 2017. It was also held in the Shakti Vahini case, where there was which was a public interest litigation raised against the harm and threats faced by couples in intercaste marriages. And in all these cases, the court has held that there is a fundamental right to life and privacy in the right to choose one's partner. So when this law will be decided, the constitutional validity of this law will be decided by the courts, it's hard to see that this will, withstand the tests of Article 14. This is perhaps the first law of this kind, and there are many other states that have voiced, state governments that have voiced similar sentiments of passing such laws. Madhya Pradesh has announced, the government, that they are also thinking of such a law which bans religious conversions for marriage. Karnataka has announced that it's looking into it. Other state governments like Assam has also announced that. So we'll have to wait and see whether other state governments pass such similar laws.